Hi everyone, great to see so many people join us online. Welcome to this Mathys Squire webinar on new changes to the EPO guidelines on description amendments, why it matters, which will be presented by Andrew White and Hazel Ford, UK and European patent attorneys at Mathys Squire. They'll be introducing themselves just a little later on. My name is Saba Ismail, BD exec at the firm, and I'm delighted to be your host for today. Just before we start the session, I would like to highlight an upcoming webinar. You can see from the first slide that we'll be hosting a session on AI in life sciences, patenting do's and don'ts. This will take place on the 25th of February. If anyone's interested in registering, there will be a link circulated post this session. Great. So without further ado, it's my great pleasure to hand over to the presenters who'll be kicking off this session.
Thanks, Saba. Just a quick introduction so you know who we are when we're speaking. My name's Hazel Ford. I'm a partner working on the life sciences and chemistry side of the firm at Mathys Squire.
And hi, I'm Andy. I'm a partner in the IT&E side at the firm as well.
Great, so let's see what we're going to talk about today. The idea of amending the description of a European patent application isn't something that's new. The EPO generally wants the scope of the description in a granted patent to match the scope that you have in your granted claims. So if you've amended your claims during prosecution, then it is usually necessary to also make some amendments in the description before the case is allowed by the EPO. Until recently, it was possible to meet the EPO's requirements for doing this with a fairly straightforward and standardized approach that could be applied in most cases. Things started to change last year when the EPO introduced some new internal guidance for its examiners, which set out some much stricter requirements for what is needed when patent applicants are amending their descriptions. And since that happened, we've been receiving some much more detailed objections from some EPO examiners that we think correspond to the internal guidance that they'd been receiving from the EPO. But so far, the approach at the EPO has not been very consistent, and there have still been some examiners who have carried on with the previous approach and have been accepting the more straightforward style of amendments. So what's happened now is that the EPO is updating its guidelines for examination document to incorporate this new guidance on amending the description. The new edition of the guidelines has just been published online, and it's going to come into force on the 1st of March this year. We're going to talk you through some of the changes today, but the take-home message is that this is probably going to increase the burden on applicants when they need to produce an amended description. As we'll see, if you have a relatively short and simple patent application and you haven't made many amendments to the claims during prosecution, then it may still be quite straightforward to meet the EPO's requirements for amending the description. But in real life, a lot of applications are long and complicated. Certainly from my point of view, on the life sciences and chemistry side, it's not at all unusual to have a patent application that could be 500 pages long. And so amending the description in these cases to meet the new requirements is probably going to be a lot more time consuming and require a lot more thought than we're used to at that stage. So a quick overview of what we're aiming to get through in this webinar today. We're going to walk you through the changes in the guidelines in relation to these description amendments. We're going to flag some of the possible pitfalls and talk about why this matters in practice. And as we go along, we'll try to highlight some of the key issues with a few examples. So I'm going to hand you over to Andy, and he'll start taking us through the main changes.
Thanks, Hazel. So why do we have to amend the description at all? Well, really, the legal basis is Article 84 EPC, which holds that the claims shall define the matter for which protection is sought, and that they shall be clear and concise and be supported by the description. And that is the key bit, really, that they should be supported by the description. So the guidelines, they interpret this legal basis, and they also apply some established case law. And they previously held that any inconsistency between the description and the claims should be avoided if it may throw doubt on the extent of protection and therefore render the claim unclear or unsupported under Article 84. But the new guidelines that will come into effect from 1st of March this year go a bit further and now state, and I'm just going to read the second paragraph from the slide there to you, where parts of the description give the reader the impression that they disclose ways to carry out the invention but are not, or due to amendments to the claims are no longer encompassed by the wording of the claims, these parts often throw doubt on the scope of protection and therefore render the claims unclear or unsupported under Article 84. But they go on to say in stronger terms, the description must be adapted to the claims in order to avoid inconsistency between the claims and description. So we've got that much stronger language now that the description must be adapted. So the new guidelines go on to say that embodiments in the description which are no longer covered by the independent claims must be deleted. For example, if the description comprises an alternative for at least one feature which is no longer covered by the amended claims, unless these embodiments can reasonably be considered to be useful for highlighting specific aspects of the amended claims. In such a case, the fact that an embodiment is not covered by the claims must be prominently stated. So there must be an explicit disclaimer that subject matter is no longer claimed. To support this amendment, the guidelines refer to a Technical Board of Appeal decision T1808 of 06, and I'll touch on this decision later on in the webinar. So in some cases, amending the description can be pretty straightforward. For example, in cases where there is a clear unity objection, this requirement seems relatively straightforward to implement. And the guidelines actually give an example relating to a vehicle which has an electric motor in one embodiment and an internal combustion engine in the other embodiment. And the guidelines note that if the claims are all amended to specify a vehicle employing electric motors, but one of the embodiments in the description and drawings employs a combustion engine instead, then the inconsistency can normally be rectified either by broadening the claims, assuming that the description and drawings as a whole provide adequate support for such broadening. And just between us, that does sort of beg the question as to why the claims were limited to a vehicle employing an electric motor in the first place. Anyway, or by removing the excess subject matter embodiment with the combustion engine from the description and drawings. So they actually want the other embodiment to be removed or explicitly disclaimed. And the guidelines say that if you don't delete it, alternatively, this embodiment must be marked as not being covered by the claimed invention. For example, by stating that it is an embodiment not covered by the claimed invention. However, as Hazel mentioned, in many other real-life scenarios, this requirement is harder to implement in practice. And here we've copied an extract from a real-life examination report, and we've both seen this exact same extract copied and pasted in many other examination reports in the last few months. I've even seen a couple today where it's exactly this same wording. So I think this is must be based on their internal guidance. And the first paragraph notes that if an independent claim has been limited to a feature A, then alternative to this feature A must either be deleted or it must be stated prominently that they are not encompassed by the claims. The second paragraph relates to combinations of features and perhaps is where things can get a bit more tricky and difficult to implement in practice. It describes an example where an amended independent claim comprises features A, B, and C. And it mentions that if an example is given where only features B and C are used, but doesn't explicitly say that feature A is also used or not, then this must also be marked as not being part of the invention. But I think what gets tricky and where it's ambiguous here is whether the embodiment using features B and C could also use feature A, but it isn't explicitly disclosed in the description whether or not it does also use feature A. I think, at least in the early days, you might get some examiners that say, well, hang on, it doesn't, applying the guidance we've been given, if it doesn't disclose all three features, then it's not part of the claimed invention. And then you're going to have to argue with the examiner, well, actually, no, hang on, look, the skilled person would understand that these features could be used in combination, and therefore we don't need to explicitly disclaim it. I think it's just an area where it may seem simple in the examination reports and in the wording here, but I think in real life is where bear traps can lie. So I think, as most of you will know, we did have to amend the description to some degree anyway previously. And previously a common approach had been to simply amend passages that are broader than the claims or that relate to non-claimed embodiments by normally replacing something like the word invention with something like disclosure, and by replacing embodiment with something like example or instance. But the EPO has now made it clear that this approach is no longer going to be enough. And if passages that don't align with the claims are retained in the description, then further amendments will be needed to make it much more explicit that they do not relate to the invention as claimed. The new guidelines make it clear that it has to be explicitly specified that passages of the description relating to non-claimed embodiments are marked as not describing part of the claimed invention. So if we've got to prominently state that something doesn't form part of the claimed invention, what does that actually mean in practice? What do we actually say? How do we amend the description? So if we take the very simple example of the vehicle with the electric motor and the internal combustion engine that the guidelines gave earlier, where the description refers to these as alternative embodiments, if the independent claims recite that the propulsion means comprises, say, an electric motor, then one could amend the description as follows. And basically just add an explicit statement that the embodiment where the propulsion means comprises an internal combustion engine is not forming part of the claimed invention. And some of you may already have seen this. I've seen examiners already introducing text like this in Rule 1703 notice of allowance communications, where they've actually started adding this in themselves to embodiments that clearly do not align with the claimed invention. But there is some other alternative wording they could use if you don't want to be so black and white, or if it may not be so applicable. So some wording may be, for example, disclosed herein, but not forming part of the invention, or the following examples, aspects, embodiments are not according to the invention and are present for illustration purposes only. Or another one here, the following example is useful for understanding the claimed invention. I have used that a few times. I think I have a slight doubt as to how an examiner and how people may interpret this statement. And I don't know, Hazel, what your thoughts are on this, but it's definitely something that sort of I've used where it's not clearly not part of the invention, but you know, the examiner clearly wants us to amend the passage in some way. So I've put this in, sort of trying to hedge my bets. I mean, what do you think?
Yeah, I agree with you. I think I've had examiners suggest this kind of amendment recently when they appear to be applying the new approach, but for me that doesn't kind of meet the new requirement of making it clear that it's not part of the invention. It doesn't really say whether or not it's part of the invention. So I think I guess some examiners may accept it, but it doesn't seem quite enough to me.
Yeah, I think I'd agree. So you know, that's something we could certainly try if you're you know, not happy with something so black and white. But I think we both have a feeling that future examiners may push back on even that language. And then other amendments that you could make, maybe where you've got very broad passages, you just describe them as relating to the disclosure, and then explicitly state elsewhere that in the invention feature X is, and sort of try, without having to amend huge swathes of the text, you can have some sort of lighter touch amendments in places just to, you know, explicitly say the invention is this, and that might be another halfway house. But again, you know, a lot of the time it's very case specific, and that's, I think, where a lot of the time and energy is going to come in. There isn't necessarily a quick fix.
So the issues that Andy's been talking through are the ones that are probably going to be relevant for all cases and in all areas of technology. There are also some comments made in the guidelines that might be a bit more technology specific, and one of these is the one at the top of this slide. This relates to subject matter that is excluded from patentability at the EPO. And under the new guidelines, if you have subject matter that can't be patented, as well as not including that subject matter in your claims, you now also need to make sure it's not presented in the description as being part of the invention. And one of the most common situations where this is likely to arise in practice is in the context of methods of treatment. As I'm sure many of you will already know, methods of treatment are not patentable at the EPO, but it is possible to claim inventions in this area by drafting them in a particular format that is acceptable to the EPO, that refers to an agent for use in a method of treatment. Under the new guidelines, as well as dealing with that in your claims, you also need to deal with it in the description. So at the bottom of this slide, there's some example text which you might have in your patent application. Under the new guidelines, this text is going to be a problem because it says that the invention provides a method of treating a disease. So the EPO, if we look at the text at the top, the EPO suggests a number of different ways that you could deal with that problem. The first option would be to just delete the whole paragraph, but that's clearly not something that's going to be acceptable in most cases, because you may well still have claims that are relating to this subject matter, just presented in a different format. And at that point, you don't want to delete all the passages in the description that are going to support and enable those claims. So a second option on the next slide is the EPO suggestion for prominently marking as not being according to the claimed invention. This is obviously better than deleting the whole paragraph, but again, I can see that people may not be keen on doing this if they do actually have claims relating to these treatment embodiments. They may not want to put in an explicit statement that this is not part of the invention. So a third option would just be to convert this paragraph in the same way that you would have converted a method of treatment claim into the EPO format of compound for use in the method of treatment. In this example of a passage, this is probably going to be the easiest option, and it does then allow for all the rest of the disclosure of treatments to be retained as still being relevant to the invention. But while this works in this simplified example, as we keep saying, it might not always be as easy in practice without the need to substantially amend the text in the description. There are many patent applications that are just not drafted in a way that is going to make this kind of amendment easy. And so we may find that we need to take different approaches in different cases, or indeed we may need to take different approaches in different paragraphs within the same patent application. So another addition to the guidelines relates to what the EPO calls claim-like clauses. And what they mean by this is if you have a section in your description that describes the invention using the same style and layout that you would have in a set of claims. So, for example, you might have a series of numbered paragraphs in your description where paragraphs 2 and 3 both refer back to paragraph 1 in the same way that you might have claims 2 and 3 depending on claim 1. The EPO doesn't like these claim-like clauses because, as you can see from this slide, they consider that if the clauses don't match the scope of the claims, then they may cause a lack of clarity. And if they do match the claims, then they may just be an unnecessary duplication that isn't needed in the patent application. This is a point that has been specifically called out in the new guidelines, so it seems that the EPO does feel quite strongly about it, and the EPO is requiring that if you have these claim-like clauses, you either need to completely delete them or you need to amend them to avoid claim-like language. I'm not quite sure how much amendment would be required to take them away from a claim-like format, but I can imagine that in some cases that might not be straightforward. In most cases, then just deleting these claim-like clauses might not be a problem because the relevant subject matter will usually be described somewhere else in the application. And so we've been seeing these kind of objections for a while, and generally people have just been deleting them. But we are aware that some people have been using these types of clauses as an alternative to parts of the detailed description to allow them to describe many different embodiments and combinations of embodiments in a more efficient way than you could do if you wrote it out longhand in the description. In those cases, I can see that the EPO asking you to delete all the clauses could be much more problematic. And I would certainly say that in view of these changes in the guidelines, that is not an approach that we would recommend people to take when they are drafting their patent applications. So there are a few other additions in the guidelines that perhaps don't add much to the other requirements that we've already discussed, but that may help to illustrate the general approach that we think the EPO is looking for here. One point to note is that the new guidelines particularly emphasize the need to amend the field of the invention and the summary of the invention sections of the description. In my recent experience, even when examiners have been quoting the new guidance and the stricter requirements, they seem to have been more focused on whether the summary of the invention is consistent with the scope of the claims, and perhaps they've been a bit less concerned about the later sections of the description. I don't know whether you agree with that one, Andy?
Yeah, I would. I think, as long as you make some amendments in the summary section and the main detailed part of the description isn't blatantly contradictory, then I think they lose the energy to keep going and they're sort of satisfied. So yeah, I'd agree with that.
Thanks. I mean, obviously that's only our personal experience so far, and it's possible that things could get worse when the guidelines come into force next month. But it does seem that there's at least a possibility that the degree of amendment that is suggested by the guidelines might not be quite as bad as it appears, and that if you kind of pay careful attention to things like the summary of the invention and get that amended to the examiner's satisfaction, then perhaps it may not be quite such a burden to deal with the rest of it. A second point on this slide is that, as well as dealing with passages that relate to non-claimed embodiments, the EPO also emphasises that you need to think about whether amendments are needed in passages that relate to features that are required by the claims. So if you have terms like preferably or optionally or in some embodiments, when you're describing a feature that is a requirement of your independent claims, then the EPO is going to want you to tighten up that language. So if you have in some embodiments, you may need to change that to something like in the invention, so that that part of the description also matches the claim scope. And then finally, just very quickly, the changes that we've always had to make at the EPO are still needed. They're still set out by the EPO. So, for example, the EPO requires that the cited prior art documents are mentioned in the background section of the description. So you might need to add those once examination is finished to meet that requirement. There are some phrases that the EPO doesn't like incorporated for reference or spirit and scope of the invention, and they're still going to ask us to delete those phrases from the description. And then if the examiner spots any patent application numbers in the description, then they may well ask for those to be either deleted or replaced by the patent publication number. So all of those changes are also still required. And the things we've been talking about today are in addition to all of those changes. So I'm going to hand back to Andy now so we can move on to why this matters.
Yeah, thanks, Hazel. So what if you don't want to amend? What if you want to resist amending the description, resist perhaps what the examiner is proposing? Well, the new guidelines make it pretty clear that the next action will be a summons to all proceedings. And the real risk of that is that there is a real risk of refusal. So I think this is something that we need to take seriously. But hopefully with our guidance, it's something that we can address. So why does all this matter? Why is amendment of the description so relevant? Well, an obvious concern is whether amendment of the description may have an effect on or change the interpretation of the claims. And I think I've just seen one of the questions come in that talked about whether amendment may have a prominent role in subsequent opposition. And amendment of the description, as we'll see in a minute, could have an issue, perhaps added matter post-grant. So it is something that does need to be considered. So as we've heard, Article 84 EPC makes it clear that the claim shall define the matter for which protection is sought. And the guidelines make it clear that the meaning of the terms of a claim must, as far as possible, be clear to the person skilled in the art from the wording of the claim alone. So from Article 84 and the guidelines, one may be forgiven for thinking, perhaps, that the claims under European practice should be interpreted in isolation of the description. And this is indeed the anecdotal approach that I'd say I experienced from some examiners, and this with some examiners would seem to adopt. However, on the other hand, Article 69 EPC holds that the extent of the protection conferred by a European patent or a European patent application shall be determined by the claims, but that nevertheless, the description and drawings shall be used to interpret the claims. And Article 84 EPC also says that the claims shall be clear and concise and be supported by the description, as we saw earlier. And there are numerous other EPO decisions in which statements in the description have been used to interpret the claims. So it's therefore clear that under European practice, the description can and is used to interpret the claims. So at this point, I thought it might be worth just turning to the T decision that's referenced in the guidelines, T 1808 of 06, and just run through what happened here, because I think it does have some relevance for post-grant as well. So in this decision, claim 1 relates to an oxygen absorbing label comprising a sheet of moisture absorbing paper. And I think this label is intended to be put into packets of foodstuffs and things like that. The text as originally filed indicated that the labels of the present invention are intended for either high moisture environments or low moisture environments. And this was found in the first sentence of a paragraph near the beginning part of the patent specification. However, the rest of that very same paragraph that immediately followed the sentence that said they could be used for either high moisture environments or low moisture environments indicates that in low moisture environments, a moisture carrying material such as a hydrogel is needed to release moisture to enable the oxygen absorbing action. However, the remainder of the paragraph, so the bit that followed on from the sentence that said that they could be used for either high moisture or low moisture, that was deleted during opposition. However, the opposition division allowed this and said that, well, if you apply Article 69 EPC, you would understand that embodiments not comprising a sheet of moisture absorbing paper were excluded from protection and thus ruled out. However, at appeal, the opponent argued that either low moisture should be deleted from the first sentence or the entire paragraph should be deleted. And I think just to give you a bit of context, I thought I'd show you the paragraph. So up until you can see the first sentence has all been striked through, at least hopefully you can, and ends with the word environment. So that's the first sentence. Everything else in that paragraph was initially deleted. And as you can see, as you sort of progress through about halfway down, there is very low moisture, and in the labels of the present invention may contain a moisture carrying material such as a hydrogel to release moisture to activate the oxygen absorbing action. So you can see here that really the first sentence, when it talks about being suitable for use in low moisture environments, the specification then teaches that actually in such low moisture environments that you need a moisture carrying material such as a hydrogel. And the board judged that actually these sentences have to be understood in context with each other. And they said that it is clear from these passages that only the high moisture environment is connected with the moisture absorbent capacity of the paper, and that instead for the low moisture environment, this requires a system which releases moisture to the environment. And so, contrary to the provisions of Article 1232 EPC, so that's the provision relating to added matter, deletion of these passages, without deleting the first sentence of the paragraph would therefore have an impact on the meaning of the terms high moisture environment and low moisture environment, because when standing alone, these purely relative terms are open to different interpretations. So I think what this decision highlights is that it is clear that amendment of the description can affect the interpretation of a claim and may also raise added matter issues post-grant. So while it may be desirable to delete passages to the description to perhaps have a broader claim scope, careful thought needs to be given as to whether you might be opening yourself up for an added matter attack post-grant.
So Andy's been talking about whether the description is relevant when the EPO interprets the claims. But of course, we need to remember that a European patent is generally litigated in the national courts of individual European countries. And in particular, that it's those national courts rather than the EPO that will look at any questions of patent infringement. So I'm going to give some comments today based on the position in the UK, but it is worth noting that the courts in different countries around Europe may not necessarily interpret a set of claims in the same way, and that different national courts could have different approaches on whether the description should be taken into account at all, the extent to which equivalence outside the literal claim scope might infringe, and whether or not any amendments that have been made during prosecution could influence the interpretation of a claim. So from a UK position, in 2017, the UK Supreme Court issued a decision in the Actavis versus Lilly case, and the Supreme Court's decision included guidance on a number of aspects of claim interpretation, particularly in the context of whether a variant will infringe a patent claim. The court identified two different questions here. The first one is the straightforward question of whether a variant is going to infringe under the normal interpretation of the claim. But the second one is the more difficult question of whether, if you have a variant that falls outside the literal wording of the claim, then can it still infringe if the differences are deemed to be immaterial? The court looked in particular here at a situation where you have a variant that achieves substantially the same result as the claimed invention, and it does that in substantially the same way as the claimed invention. And they concluded that this type of variant can infringe a claim, but that it's important to consider whether the reader of the patent would have concluded that the patentee intended for the claims to be limited to only their literal scope. So based on this question, the court could look at the patent as a whole to see whether there is any indication in the patent as to whether the claims were intended to be read narrowly or not. And this raises the question of whether a strict approach from the EPO for amending the description may have a knock-on effect on this type of claim interpretation. So if the patentee has been forced by the EPO to amend the description to say that any embodiments that don't exactly align with the claims are not of the invention, then is that something that could be taken into account by a court in the UK later, and may imply that only the literal claim scope was intended to be covered. So I think there is definitely a question, at least from a UK point of view, as to whether a requirement to insert these kind of explicit statements in the description could have an impact later on as to whether equivalence would still be protectable under the UK approach. So in a simplistic case, if your description presents a list of alternatives and you're only claiming one of them, then the type of amendment that the EPO is asking for might not make much difference in practice. And that's illustrated in this decision, which came from the UK courts last year. What happened here was that the UK judge found that if the original specification describes multiple alternatives, but that you only claim one of them, then you may be deemed to be disclaiming the non-claimed options from the scope of your invention. So using an alternative to what is set out in the claims may not be an infringement if that alternative is something that was presented as an option in the application, but the patentee chose not to claim it. In that kind of situation, then perhaps marking those non-claimed embodiments as not of the invention might not make much difference in terms of interpretation. It probably wouldn't make the patentee's position much worse, because the mere presence of those embodiments in the description was enough in this case for them to be deemed to be outside the scope of the claims. But again, this is one particular scenario, and in real life, things may not be that simple. In most cases, it's not as simple as the claims focusing on one from a list of alternatives. There may be many passages in the description that describe similar or overlapping embodiments that are very close to what's in the claims, but maybe do not align exactly with all the features that are required by those claims. And so I guess the question that we need to wait and see is that if the EPO is actually going to require us to amend the description to explicitly state that all of those embodiments do not form part of the invention, then is that actually going to affect the interpretation of the claims at a much later stage, and in particular whether any equivalence would still fall within the scope of the claims.
So well done for getting this far. As we're coming to the end of the webinar, we will have some Q&As after this, so don't worry. But just to sum things up, in short, the EPO are getting stricter on description amendments, and this has been happening over the last few months, at least in our anecdotal experience at least, but it's likely to become more widespread once the guidelines come into force next month. We don't yet know how strictly these requirements will be applied in practice, although again, anecdotally, we've experienced some examiners who are more lenient than others, although whether that will change when it comes to 1st of March and the guidelines come into legal force, we will have to wait and see. Careful thought needs to go into amendments, particularly where it is not clear-cut that there are alternative embodiments. And the long and short of it is that it's likely going to cost applicants more.
Thanks so much, Andy and Hazel, for that insightful presentation. It is time for the Q&A, and we do have quite a few, but I'll hand over to Hazel. Perhaps maybe she could start off the Q&A session for us.
Sure. I'm just reading through all the questions. But there are a few questions here about divisional practice and whether this is going to make any difference to that. I would say that it shouldn't make any difference whether an application is a parent or a divisional. We are talking about amendments that are made during prosecution of an application. If you make these amendments and then file a divisional application, then I would expect people would normally be using the original text of the first application, not the text with these amendments in it. So if you do have to make these amendments in the description of one application, that shouldn't have any effect on your ability to, for example, claim deleted or disclaimed embodiments in a later divisional application. Do you want to have one, Andy?
Yeah, I mean, there's quite a few here. I mean, just jumping in. I mean, one of the points was that added matter is in comparison to the application is filed, not the patent is granted. Correct, but I think the point is that if you are deleting a statement from the description that affects the meaning of an earlier statement so that it can be broader than that which the reader would have originally understood that statement to mean, then you are still broadening the scope of you're still teaching the skilled person something new that they weren't taught originally. So you are adding matter by deletion still. I think that's something just important to bear in mind and get your head around, that if you're sort of deleting how something could be interpreted, that could be broadening how that term is interpreted. And then another question was, does this just apply to after you first file description? In other words, is it okay to have embodiments that are not claimed in the original description? Yes, that's absolutely fine. You're going to need that. You might have several inventions in there, and you're going to file divisionals to them. This only relates to getting to the point where they're going to allow the application, and therefore making sure the description is in conformity with the claims they're going to allow. So I think there was another question that you could say that someone asked about whether you could put in a statement like the description will be brought in line with the claims once agreement has been achieved on the formulation of the claims. I think at least my practice tends to be, I wouldn't make tons of description amendments at the beginning, but as you're sort of getting to a point where you think the examiner is more likely to allow it, and or to perhaps get it over, to make the examiner more positively disposed towards the case, then I might try and make the description amendments then as well to sort of nudge the examiner to say, look, isn't everything ready now? Can't you just give me a notice of allowance? But I might not amend it, when I first get the searched opinion or something like that. Do you want to do some, Hazel, again?
Okay, I'll pick out some more. There's one comment here whether it would be easiest in the simpler scenario where you have several embodiments but only one of them is claimed, whether it would be easier to just delete the unclaimed ones. And I think in a lot of cases it may well be. I think if you do have what I would call a real lack of unity in your patent application, and you do have some very different embodiments disclosed, then it may just be simpler, and you may be happy to delete from the description the embodiments that you're not claiming, and that may actually be a sensible thing to do in the long run, because you may save translation costs and things like that later on when your patent is granted. I think where it becomes a lot more complicated is where those other aspects include information that is relevant to your invention. For example, kind of background information as to how things might be produced or how things might be tested. Then there are still quite a few scenarios where things that on the face of them don't appear relevant may have useful information that might be relevant for example, enablement of your claims. And so, yes, I think there will be some cases where it will be straightforward and the best option may just be to delete. But in a lot of cases, I think that there will be a kind of motivation to try and find a way of keeping the text somehow rather than deleting it.
Someone else has asked, where's the question? When drafting new patent applications, what are some application drafting techniques you'd recommend in anticipation of these new rules be applied? Just what a clear thing that I think we always struggle with when it comes to European practice is when, and I'd imagine you have the same issue, Hazel, is when everything is described as being in an embodiment.
Yeah.
So you have tons of, every paragraph starts within an embodiment and it describes something else.
Or every sentence.
Well, every sort of, new sort of idea that's being discussed. Yeah. That's a main issue really for Adamata, in that the EPO will say that you can't combine, these different embodiments. If you are, they will reflect under what they call an intermediate generalization, in that you may be extracting features piecemeal from separate embodiments, or that there's just simply no teaching that these embodiments can be combined. And I think with these new guidelines changes, there's another reason not to use that terminology now as well, in that it makes it even harder to, you have to explicitly say, is that claimed or not claimed? So I would try and avoid sort of describing everything as in an embodiment. Hopefully that answered that question.
Yeah, I was going to say I agree with that. I think the EPO tends to focus on the word invention and the word embodiment, and if you can make it clear that you're describing these things without using those words, then a lot less amendment is going to be needed at a later stage. If the way it's described is more ambiguous and it's not specifically relating to it being part of the invention, then I think that will make it a lot easier.
So there's a question here, maybe we could both answer, see what we think, Hazel. So sometimes I put embodiments in that I have no intention of ever claiming, but I want to make sure that these embodiments are published in the public domain so that no one else can patent them. Is this still advisable and valid? I mean, so you're talking about really the disclosure effect. It's still, I mean, I still think there is some validity to that. I think what I would be concerned about is the, as Hazel was discussing, the sort of disclosed but not claimed is disclaimed. And obviously everything's context specific, but if in any way it could be considered to be an equivalent, or one might argue that those other embodiments are equivalents, then if you're not claiming them, then there may be some repercussion for how the scope of the claim is interpreted with respect to equivalence. But if it's clearly something completely different, or different embodiment is clear cut, like the example of the electric motor and the combustion engine, and then you could just delete it from the specification as it gets to grant, then I don't think that's an issue. I don't know. Do you have any thoughts, Hazel?
I agree with you. I think if it's something that is only there for that purpose, that is not really related to what's in the claims, then I think there's no harm in having it there. You just need to be aware that you might need to delete it before the patent gets granted. But if it's something that's close to what you're planning to claim, then you should just be aware that then that might have an effect on the interpretation of the claims.
So there's another question here about figures and also amending other parts of the application, like examples and drawings. So I'm sure you've got thoughts as well, Hazel. I mean, in my experience, what generally we would do is we wouldn't actually make any amendment to the descriptions themselves at all. Generally, what the EPO examiners have wanted to see is when you've got the brief description of the figures. So, when you're listing, figure 1 of this, figure 2 is that. They want an explicit statement as to whether, that if any of those are not part of the claimed invention. So it might be, figure 3 describes an alternative arrangement, and they want you to put in that explicit disclaimer saying not forming part of the claimed invention. So that's sort of my experience of that. What about you, Hazel?
Yeah, so I mean, it's the kind of thing that tends to come up more with the examples on the life sciences and chemistry side, and we do regularly get some examiners asking us to clarify which examples do fall within the scope of the invention and which don't. And if there are examples that don't fall within the scope of the invention, we may well be asked to mark them as reference examples. Again, it's quite variable in different cases, and in some cases it will be straightforward and clear cut. It tends to come up on things like chemical cases where you have a series of examples that each describes a different compound. So if you have examples that describe compounds that are outside the scope of the claims, then the examiner may well ask you to mark them as reference compounds or reference examples. But I think in most cases, the examples tend to be a bit more ambiguous, and they may well still be relevant to enablement or understanding how something works, even if they're not directly relevant. And I would say that certainly so far, I've only really seen examiners pushing for amendments in the examples where it is more clear cut that something is definitely outside the scope. And I think if the examples appear to be relevant in some way to the claims, then the examiners so far haven't been requiring any further amendment other than if it specifically talks about invention or embodiments.
We have had a couple of questions sort of relating to legal basis and why the EPO have suddenly sort of changed like this. I mean, so the legal basis they give in the guidelines is that T decision that I discussed. I mean, anecdotally, when this sort of I first experienced this happening in examination reports, I think it was about September last year. I had the examiner phone me up and walk me through it and explain to me that this was new internal guidance he had got, and he disagreed with it and was very sympathetic to us as applicants. And as we said earlier, some examiners do seem quite sympathetic, and as long as you amend the summary so they can it sort of passes off that you've done an attempt at bringing the description into conformity, then they're happy. But as we said, that was before these new guidelines were coming into legal force. Whether that position will change after 1st of March, I think we're yet to see. But I think it's something we should all be aware of and cautious of. I don't know if you've got any other thoughts on that, Hazel.
Yeah, no, I agree. I've also had a few examiners phone me up in the last few months to kind of warn me that I'm going to receive 3 pages of objections to my description, and to basically explain that this is the guidance that they've been told to follow. In practice so far, a kind of what I'd call an intermediate approach is probably been accepted in most cases. I personally haven't had any examiners pushing for an extreme approach based on what we've been talking about today. Somewhere where we've clearly made an effort to try to deal with the issues has been accepted so far by all examiners. But as Andy said, because this is going to be kind of formally introduced into the guidelines, we don't really know how strictly it's going to be followed going forward, and whether we are going to have to think a lot more carefully about this in future.
Just trying to run through if there's any more questions.
Do we have time for just one more?
I mean, one question that's come up is the EPO says that you don't have to delete it if it's reasonably useful for highlighting specific aspects of the claims, and what does that really mean in practice? And I'm not sure what that means in practice. I think we'll have to wait and see how that plays out with the EPO going forward. But what I think it gives us is an avenue for putting forward arguments to try and justify keeping things that we do want to retain in the description that we don't want to have to delete. And if you can find something in those passages that you can argue is relevant to the scope of your claims, even if it's not exactly the same thing that you're claiming, hopefully that's something that we can use to try and persuade examiners not to take too strict an approach. I don't know if you have any thoughts on that, Andy.
Yeah, I think exactly that. I mean, on a case where I had oral proceedings recently, and then we were getting to the description amendments, I was trying to argue with the chairman, saying, well, actually, look, I think they're useful for showing how the invention works, and the examiner sort of seemed fairly happy with that as a reason to not have to amend the description too much. I think it as long as you've put somewhere you've kind of made an attempt at amending the description, then I think if there are other bits that you're particularly concerned about, then you might be able to sort of say, well, this bit we're worried about. You don't have to. Don't make us amend it here, please.
I think we've come to the end of the webinar now. It's just really, the only thing to say is really a huge thank you for everyone that's joined in, and we really hope that you found this session useful. Just to mention that you will be redirected to a feedback form. We would really love to hear your thoughts about this webinar and any other webinars that you'd like us to cover in the future. And lastly, to mention that the presenter email addresses will be circulated. So please feel free to email them directly. Oh, and as well as it being on screen right now. If there's any other questions that you felt that has been covered today and you'd like to take offline, please feel free to get in touch with us. And lastly, just to say thank you and so much for joining us, and we hope to see you at a future webinar. Thanks, everyone.